Okay, so we are back on our third video here and talking about different actions that can be brought under CERCLA. I mentioned this in an earlier slide, but natural resources action. So assume you have, Acme toxic chemical company somehow has a release of some toxic chemical that affects a natural resource. So, fish in a river hurting, a wild animal population, or maybe somehow bothering public land, but not private property, right? So it's not like if it's a private property, then the individual can bring an action. But if it's a natural resource, governmental, state, or federal, a trustee of that natural resource can bring an action. So that action under CERCLA, they have to show, what of these resources was damaged, when it occurred, what substance, whatever, toxic substance caused the damage, how this resource was exposed. Was it air? Was it leakage or whatever? And the standard, it's not strict liability. There is it's preponderance of the evidence standard. So that means, more likely than not, they get the scales. If the scales go one way than the other, that's your standard to prove liability under CERCLA for a natural resource. Um, so cost recovery action. So if somebody has done a cleanup of toxic stuff, Section 107 of CERCLA allows for recovery of those costs. So you have to identify the responsible parties, um, and it has to be an actual release or threatened, like imminent, from a vessel, right? The boat or some sort of a vessel on water, or a site, a facility, and whatever release occurred, there was a cost to clean it up, to eliminate damage to the resource or to people or something like that. So things that you can recover for would be, sampling. Okay, well, I have to check the soil, I have to check the air, I have to check the water, um, figuring out what substances, right? Detecting, identify, and disposal of these hazardous substances, any investigation of danger to people, the EPA, what their overhead was, their administrative costs. So these are brought by the EPA to recover from these actions, and attorneys' fees. Um, so these are things that cannot be recovered, just general damages or medical stuff. So it has to be necessary. Whoever that party is, be it the EPA or an individual or a corporation, they have to be in compliance with the National Contingency Plan. And, again, the EPA knows how to do it. Uh, Harder for private citizens to bring that. And if you're recovering, if the EPA has done it, that's, the Superfund money, right? So the Superfund is the money that was created from when CERCLA was initiated. From It was a tax that was placed on chemical and petroleum industries, and all that money went into this trust for the Superfund for these cleanups. But so these days, right, that tax expired in 1995, and just general revenues subsidize the Superfund, and it's kind of being depleted a little bit. Money went to Katrina, flooding, hurricanes, stuff like that, and now they believe, the EPA believes, or many people believe, that this Superfund is underfunded. So we're working to recover that Superfund money so that the EPA will have more money on hand for emergency type cleanups. So that is recovery. Okay, so abatement actions. All right, so that was cost recovery. One, if the EPA or a private individual cleaned up and they're looking for money, to get that money back. Okay, so an abatement action, you're like, okay, this is under CERCLA Section 106. The EPA, if they have identified this as some sort of endangerment that hasn't happened yet, but it's imminent, and if it happens, it's very dangerous. The EPA under Section 106 can ask the court to make a PRP, right, a potentially responsible party, to do abatement of this site. And this isn't a Superfund action. The EPA goes into court saying, like, this is going to happen. This is scary. We got to get these people to clean it up before people get hurt. Okay, so so they can go into court under CERCLA Section 106. They Under Section 106, it's not just money. They have equitable remedies. Remember, equitable remedies are where you're like either making someone affirmatively do something or stop doing something. So it might be like an injunction of some sort, like you have to stop putting more waste into a certain area, or stop adding to this dump or whatever, or you have to affirmatively clean something up. Okay, so that's what they can either order money for them to abate it, that require them to abate it, basically, whatever the cost. So that's the powers of the courts under 106. These are these administrative orders, like these. The EPA can just go in, and if they believe that there is either an actual release or a threatened release of a hazardous substance from a facility, and they have an administrative finding. So this is a finding on their own that there's imminent, so it's coming, and substantial endangerment, and they just issue their own order that you have to abate this danger. So we're not even going to the court here. They have their own tool. And they issue this order, like, think of it like a ticket or a citation, right? They have that, and they issue that to Acme Chemical or whatever. And if after that order is issued, if that PRP objects to it, thinks it's unwarranted, they can have a conference with the EPA, and then they can, if that doesn't work out, they can go to the court and see if the EPA has violated their powers, gone above their powers. And then the court can really have a trial on it. But it's pretty powerful because the EPA doesn't need the court to do these things. They can just go in on their own and like, hey, dude, you've got to clean this up, right? So they can do that all on their own. Consent decree, we talked about this a couple slides ago, but this would be, after the PRP and the EPA have sat down, worked something out, they have to file. There's an EPA model agreement they have to file. I guess the EPA was kind of going willy-nilly on these things before '86 when the SARA amendments came in, and they put some limits on that. So, and they have something called the orphan share. So if there's like a company that no longer exists, like, well, how can they pay their share because they no longer exist? So they might say, like, I'm not paying the orphan share, so that might be part of the consent order. They might say, like, if I'm a de minimis contributor, remember we talked about that a few slides ago, they'll have this consent decree, and they're like, okay, I'm going to pay whatever, $100,000, but I'm released from future liability here. And if you don't comply, there's going to be penalties built into that consent decree for your failure to comply. It's not like you can have this agreed decree and then, like, welch out on it. There'd be penalties there. If you don't comply with these EPA orders, fines up to $25,000 per day. They are the punitive damages are allowed. Your defenses under for noncompliance would be like, I'm not even liable under CERCLA, or I'm a de minimis contributor, or somehow the order was invalid, or either the technology available or the financial obligations, they can't comply with them. Or the cleanup action that say the EPA did was not economically completed or somehow not consistent with the national contingency plan. But, I think if you are ordered to do something by the EPA, you kind of have to do it or you're in big trouble. Statute of limitations for the CERCLA, for the EPA to bring an action or for anybody to bring an action under CERCLA is 3 to 6 years from removal, not 3 to 6 years from when the waste was created or the release occurred. Okay, so that's the statute of limitations. And this statute of limitations issue kind of is important for your homework question, that Kowalski case that you'll look at. Yeah, so how you allocate liability, and when you have your PRPs, you want to know who did what on a site. It's joint and several, so all parties are equally responsible. So if the EPA just sued me, and I know that Zebra Company also contributed, I can bring an action to them to get their share of the money back, and it's called a contribution action. It's kind of more familiar in, say, like insurance cases. So if I am in an auto accident, my insurance company paid, they might bring a lawsuit against, say, like the auto manufacturer, because to get their money back, because it really wasn't the insurance company's fault. I mean, if they think it wasn't really their insured's fault. Okay, so that's a contribution action, and these contribution actions were first allowed under SARA, and again, you can have these equitable factors, right? So it's not just like you're all liable for all of it. You can think about how much was contributed, how bad was the waste you contributed, your general care, and how good you were about cooperating with the government. So this is like when back when I was practicing, I would like read through deposition about like a site, and you're talking to employees, and you're like, okay, well, what chemicals were you using in this shed or this building? Did you use, whoever I was representing, ask them if they were familiar with the names of that product and if that was ever used there, to determine like whether that was my company's chemical or my company's contribution to it. So a lot of litigation over allocation of liability under CERCLA. Okay, citizen suits, right? So if anyone violates CERCLA laws and I have damage, or who is somehow not complying with CERCLA, or if a U.S. official doesn't do what they're supposed to do under CERCLA, and then if I'm going to bring a citizen suit, I have to tell the EPA about it 60 days before. So it's not as strong of a citizen suit kind of place. It's more of an EPA statute. Federal facilities try to be immune from CERCLA, but there are waivers of sovereign immunity in CERCLA. So the government is not exempt. So these federal facilities, the EPA can go in and clean up and ask for money from that federal agency or whatever that is. Okay, so now stop this video, work on the homework, which is that Kowalski case, which is also attached. If you look in the assignment section, I've attached that case. I think it's assignment 10.4 in the book. It's on page 259. Also, there's a fun video that I'm going to just post in the regular section, not in supplemental videos, to get us ready for EPCRA. Okay. Talk to you soon.